Yes, Your Honor.
Defense?
Yes, sir.
Mr. Mason, you may proceed, sir.
Thank you very much. I know that you all would like to spend another 10 or 12 hours listening to lawyers. I can see it in your face. But unfortunately, you're not going to get to do that, at least from me. But we'll spend a few minutes. But I'll begin thinking about where we are and where we've come from since May the 9th in Clearwater to now. And we're about to put on your shoulders the most solemn responsibility that you individually or all of you have ever had to face. And all I can say about that is you agreed to be able to do it, and I hope you all survive it with good senses and pride in what you do, and just like we will, hopefully. And I'll begin my comments. I want to involve just a little bit of some philosophy. A very dear friend of mine named Milton Hirsch, an author, and in fact a judge in South Florida, advised me of this parable, and it's always fun to go through. History records that on May the 19th of 1790, the skies over Hartford, Connecticut turned from blue and sunny to black and stormy with such speed and dramatic force that the people believed the end of the world was at hand. The Connecticut House of Representatives was in session at the time. Some of its members dropped to their knees in prayer as others clamored for adjournment. The Speaker of the House, a Colonel Davenport, rose to his feet and restored order with these words: "The day of judgment is either approaching or it is not. If it is not, there is no cause for adjournment. If it is coming, I choose to be found doing my duty. I wish, therefore, that candles be brought." Today is Judgment Day in the United States, as to its Constitution. Tomorrow will be Judgment Day, as to the Constitution. Every day in which an American stands trial for his liberty before a jury. Every day in which an American is arrested or his home or property searched. Every day in which a voice is raised in speech or song. Every day in which a vote is cast or counted. Every day in which a newspaper is printed or read. Every day in which a lawyer is asked to defend an unpopular man or an unpopular cause is Judgment Day for the United States Constitution. We can cower before the storm, or we can light candles. Well, let us light some candles. On this eve of the 4th of July, the anniversary of the freedom of our country and the beginning of a constitutional government, there are some things that you're going to hear about that are extremely important. And that is the constitutional rights and constitutional protections that afford the freedom to each and every one of us in this room, and interpreted with some very special rules for Caylee Anthony. Now, when I finish, my colleagues from the state attorney's office, known for long times, will either together or divided up in some fashion, will stand and they will present arguments to you. And when they're done, I guess probably tomorrow morning as I'm standing it, Judge Perry will then read to you the instructions of law that you are required by your oath and required by the law to follow. And I can tell you now that there are going to be some questions asked about those, because in truth and fairness, we hadn't been able to get all together to finalize what it's going to be, but we're working all hard on it. You, at least, however, will not have to memorize it. You will be given 12 sets of these typewritten instructions so you can read them and discuss them, argue about them, try to understand what they mean. And I know, actually, that you will be able to, because despite how long it's been, I remember all the process of the jury selection. And I believe that you all have the cumulative and individual abilities to analyze and to resolve your questions regarding those instructions. So I'm going to tell you what some of them are, and one of the ones that governs about everything that's going to happen in this case is an instruction that is entitled, when you get to them, plea of not guilty, reasonable doubt, and burden of proof. And I do not intend to belabor all of that now, but there are some things that control the major lighting of candles that we're going to do in this case. And that is, Caylee Anthony is not required to present evidence or prove anything. And you may remember that that concept was discussed with you in Clearwater. Not just by the lawyers asking questions, but Judge Perry looked to the side to each one of you and discussed that with you. And every one of you understood and agreed, I accept that. Each of you accepted the constitutional principle that is one of the cornerstones of our freedom. I'll say it again. The defendant is not required to present evidence or prove anything. And you must remember that concept with every issue that you discuss when you're back there in the jury room. You can get caught up in emotional rhetoric. You can get caught up in conflicting positions amongst you. But no matter what it is, the defendant is not required to present evidence or prove anything. Said another way that you must carry with you throughout all the discussion is that the burden of proving every required element in this lawsuit rests with my colleagues from the state attorney's office. And they don't shy away from it. They've accepted that that's their responsibility. Never forget, no matter what the issue is, they have all of the burden and there is none over here. Because that is what separates our constitutional government and freedom from so many others in the world. It is your duty to absolutely ensure that those rules are respected and honored through every stage of your discussions. The court will tell you that every element of the offenses is required to be proven beyond and to the exclusion of every reasonable doubt. Every reasonable doubt. And if the state of Florida fails in that burden of proof as to any element of the offenses, then you are required, like it or not, emotional or not, it is your solemn sworn duty. You are required to find the defendant not guilty. And that goes to every single element of each charge in this case. Only if it can be said in your conscience, in your intellectual honesty, that the state has proven the elements beyond a reasonable doubt, may you consider finding the defendant guilty. So, with every issue that is raised, burden of proof, no burden, reasonable doubt. That'll help you get through it. The court is going to tell you that it is your province to weigh the evidence, not the sparring between the lawyers and not the stacks of 366 pieces of something and boards and whatever else. You, jurors, are the ones who weigh the evidence and decide what evidence is reliable, what evidence you are skeptical about, what evidence you don't trust. It's out of the lawyer's hands. This is for you to decide. And the court is going to give you some guidance. I mean, we don't just look at somebody and say, well, I don't like the looks. Well, that guy's too old. Or he can't hear. Or whatever the issues are. You look to some rules to guide you on the evidence, such as, did the witness seem to have an opportunity to see and know things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Oh my, we've seen a lot of issues about that from that witness stand in the last 6 weeks, perhaps. Did the witness have some interest in how the case should be decided? You know, like being able to make some money or something like that. Did the witness's testimony agree with other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? That's, you heard the term from time to time, objections and arguments and stuff about impeachment. And that's what we call it when you catch somebody changing their story that they said sometime before under oath in a deposition. You have the right to believe or disbelieve all or any part of the evidence of any testimony of any witness. 100% of the people that sit in that chair, you have a right to believe all or none. That's what a jury is about. Otherwise, we use a computer with all these little things, machines going around. I don't know. Maybe I'll live long enough to see we won't even have humans as jurors. We'll have some kind of machine that decides for us. But for now, you get to weigh and judge the credibility of every single witness. The court's going to give you an instruction about expert witnesses. Remember all the people that we had talked about, go through this and that. And the judge, you declare them an expert, and the judge will tell you, ladies and gentlemen, so-and-so is an expert in this or expert in that, and you can consider that. However, you're also going to be told that like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. So just because they may have met a criteria, a threshold to be anointed by Judge Perry as an expert doesn't mean you got to buy it. You may or you may not. That's part of being a jury. Now, thinking back to your oath, your discussions with Judge Perry in Clearwater, we now are going to talk about the elephant in the room. And I know what it is, and you know what it is. My client, Caylee Marie Anthony, with the advice of counsel, made her decision to not testify in this case. I didn't reach my age and try cases this long to not know that's still on your mind. But you swore an oath as jurors to rise above bias and prejudice and media impact and so on. The judge will tell you as follows. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. Again, you must not view this as an admission of guilt or be influenced in any way by her decision. A promise you made, and a promise that must be kept if we're lighting candles for our constitutional rights and freedom. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in this case. Burden of proof, no burden beyond a reasonable doubt, and don't dare think that you can consider the fact that she did not testify. As fundamental a right as we have, born in the Constitution, in the history of our country since we've had the Constitution. Just because these are in some order, I'm going to discuss a subject that you will have to consider. Counts, you didn't hear a whole lot about, but counts 4, 5, 6, and 7. When you see the indictment, you may remember from clear order talking about it and the reading of the indictment. Allege that Caylee Marie Anthony made false statements to Uri Melich. Now, you know who Uri Melich is. You've seen him on the witness stand a dozen times. She made some false statements to him in different times and places. And the court is going to tell you that the instruction of the law is you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including not limited to, is what it says, whether when the defendant made the statement she had been threatened in order to get her to make it, and whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. I'll call your attention to some of the evidence on this. You may remember a recording made where she was questioned by 3 detectives in a small room that was described as about a 6x8 room. I think they even put pictures in to show you this tiny little room. And you remember, if you will, hearing those detectives yelling at her, 2, 3 at a time, like some TV show, not allowing her to answer, berating, arguing. So, you may also remember that in the initial part of it, interesting enough, there was a dispute among the law enforcement officers. You had a sergeant say she was not handcuffed, she wasn't arrested, and then young Mr. Everlyn comes in and says, yeah, she was handcuffed, I did it. And put her in the cage of Sergeant Acevedo's car. And the prosecution then retorted by asking, but she was free to go, right? Okay, so the bottom line is when you consider those things, consider those counts, consider whether or not the law has been met. If she voluntarily made those statements, if she wasn't under pressure, coercion, duress, not being threatened, not in a small room with 3 detectives, and she made a statement and you say it was false, well, then find her guilty of it. But the law says if she was not freely and voluntarily making those statements, you should disregard them. And if the statements are gone, so are all the counts. The initial charges, or the main charges in this case, of course, are first-degree murder, which requires the government to prove some things that are obvious. Are we arguing that this unfortunate child is not dead? Of course not. It's a tragedy. It's never been an issue in this case. So, but it's on there. You may wonder why did they do that? Caylee Marie Anthony is dead. Well, okay, yes. The death was caused by the criminal act of Caylee Marie Anthony. Now, caused by her. Well, what act? What act? You will also hear, and you will read the instructions as charged in the indictment, that this was done by a premeditated killing. And or alternatively, you will be able to consider whether or not there was a felony murder underlying that, and have fun reading the instructions on that. We're trying to make them as clear as we can, and the bottom line is there's two theories. The main thing is, what act? The judge will describe and take the time, and you'll get into what does premeditation mean. I'm not going to belabor it. You'll also be given instruction on dealing with the offense of felony murder of the first degree. And that is, once again, that Caylee Marie Anthony is dead. And the death occurred as a consequence of, and while Caylee Marie Anthony was engaged in the commission of aggravated child abuse. Now, we've been here, I'm not sure what day of the actual trial this is. The only thing I'm real clear about it is Sunday afternoon. Where, what, how, when, and why is the evidence of aggravated child abuse? All of the witnesses that took the stand didn't know anything about Caylee Marie Anthony. Confirmed that she was a loving, doting, devoted mother. She was a young girl. She's only 22. My shoes are that old. The child was well fed, well nourished, well taken care of, bright, had no evidence whatsoever of any prior trauma of any kind, no torquing of joints, no twisting of bones, no closed fractures, nothing. Or, the law says, that the death occurred as a consequence of and while Caylee Marie Anthony was attempting to commit aggravated child abuse. And that Caylee Marie Anthony was the person who actually killed Caylee Marie Anthony. All the emotion, all the suspicion in the world doesn't prove it. Burden of proof, no burden beyond and to the exclusion of every reasonable doubt. You will get an instruction hoping to help you understand what is meant by aggravated child abuse. One of the parts of that that's being added to it is a definition of willfully. Not unintentionally or not accidentally, but willfully. Causing child abuse on Caylee. I may not indeed have been able to hear everything. You may have noticed, as we both have on our tables, as does the judge, special computer where she sends me what's being said. So when I can't hear it in the acoustics of the room, I'm sitting there trying to read it. And I never heard nor read, in this case, any evidence of child abuse of any kind. I'm not going to further belabor all of those instructions because you'll have them to read, but I'm not done. It's not that easy. The instruction is going to tell you that you may find a reasonable doubt based on the evidence or the lack of evidence. Now, Mr. Baez went through a lot of things with you about what is or is not evidence. And forgive me if I repeat some of those, but I had made a list of issues that I thought were not proven in this case. You have the absolute right, of course, to disagree with me or say, yeah, that's right, and to think of some others on your own, which I know you will. So I'm going to run through a list just real quickly just to give you an idea of what we're talking about on lack of evidence. This is a criminal case. Those charges. No fingerprints on the duct tape anywhere or on the bags or anything that were searched and seized by warrant from the home. Interestingly enough, we learned that the infamous gas can with the duct tape, no duct tape, had been wiped clean. No prints. Toxicology tests. Dr. Goldberger, part of the forensic team doing the autopsy studies for Dr. Garavaglia, was charged with the duty of seeking to find chemical evidence of chloroform and several other drugs or poisons. 0. Found 0. Mr. Baez did talk about there being no DNA. 2011. The case occurred in 2008. It's not new. The only profile of DNA evidence, as you heard a little while ago, excluded, meaning that not the defendant. DNA evidence, as you heard, if you remember how much fun it was to listen to, is to try to say that this DNA evidence matches you, or not you, not meaning you, a person, somebody else. It's a statistical probability. If there are these markers on these alleles as was shown to you, the more there are, the higher the probability. And the general rule, I think they testify to, if I'm wrong with that, forgive me, that when there are those 13 markers, then the probability of that person, subject that gave that DNA, not being the one matching to that, it's like 1 in 14 quadrillion. That's 15 zeros. But if the DNA has one, just one marker that the subject does not have, that means it's excluded. Cannot be. And the FBI confirmed that the profile they got from that tape excluded Caylee Marie Anthony and the child. There was no evidence of decomposition found at the recovery scene. The entomologist talked about what must have decomposed somewhere else, and it wasn't here. no bugs, whatever, no other evidence of it. Mr. Baez pointed out to you there were no bugs from the trunk, only in the trash. The issue of chloroform was brought up from the beginning. What a media baby this was. And I must remind you about this evidence. Dr. Michael Sigmund is the one who extracted 2 bags of air from the trunk of the car at the same time, in the same way, at the same place, and took one to his lab and sent one to Dr. Vass's lab. Dr. Sigmund's lab says major compound was gasoline, and that there was some small trace of chloroform, which he also said is everywhere. Everywhere. And opposing side said, oh no, we had this shockingly high level. We don't know how much, but it was shockingly high. And as Mr. Baez said, Dr. Rickenbach said, no, very, very low. Search warrants at the house 3 times. You know, they, in your common sense experience, you know the police don't call up and say, by the way, we'll be there at 6:45 with a search warrant, be ready. Search warrants are issued constitutionally through a legal process and orders by a judge, and the law enforcement officers go and surprise. And they searched the Anthony residence. And they searched it all, as you recall, seeing pictures. They searched everything. They found no chloroform, no bottles of ingredients, no papers related to it, nothing. So then the issue, one says, what does all this chloroform mean? Was it, at some point in the case, is it chloroform used to poison this child and to knock her out and kill her? Or was it chloroform that was ultimately alleged to be found from the decomposition suspicions from the trunk of the car? Not both. And there's no evidence of what it was, so, but it sounded sexy for the media. The heart-shaped sticker deal, Mr. Baez. Laboratory analyst at the FBI says she saw an image of a part of a heart shape on the corner of duct tape, the language I recall. But when she went to take a picture of it, poof, it was gone. Poof, it was gone. And then, of course, they brought in as evidence some thick item attached to a piece of cardboard, which when it was presented to you, I don't know what number it is, but it was separated, and that had been found across from the school in the distance from this child. Mr. Baez talked about numerous other things, the searches comparing shoes and the shovel and so forth. Let's talk about some other things. Unusual in a murder case or any criminal case. Not even a hint of a claim that there was any form of admission of wrongdoing attributable to this defendant or any confession. No witness anywhere that she did anything to this child. None. 3 years of investigation and however much money. None. Why would she kill this child? There's no evidence of a motive to kill this child. Am I hearing them suggesting that she wanted to party? Well, she did that anyway. She had babysitters. The boyfriends liked this child. Everybody had a good relationship. Why in the world will the mother that you see in the video, why in the world will the mother just been so devoted to this child, trying to protect her and take care of her, wake up one day and say, well, I think I'll kill her? You learned about trace evidence, and you learned about all the scientific stuff. What we didn't learn about was anything to link any wrongdoing, as example, to the inside of the car. The steering wheel cover, the car seats, anywhere inside at all. Yet we're told that, somebody did like that, well, they can get DNA or some skin cells or move this chloroform or whatever is alleged is used as a weapon somewhere. None. I suspect that you, individually and collectively, can make a much longer list than I did, sitting here quickly, of the things that there's no evidence of. I don't know what the odor was or what there wasn't, but I was certainly intrigued to learn that at least 7 law enforcement officers on the hunt did not smell any decomposition or strong odors in that automobile. I remember Mr. Simon Birch, I suspect in Australia or New Zealand, didn't find out, the tow truck guy, said that he had a history of 6 or 7 or 8 prior experiences of decomposing humans from suicide or otherwise in cars that he had repossessed. But in this one, there may have been a little odor, he says, but with that experience and that consciousness and talking to Mr. Anthony about his missing daughter and grandchild, neither he nor George called the cops. Instead, he takes the trash out of the trunk and says, "This is your source of the smell," flips it over the fence to the dumpster. All of these things start mounting up reasonable doubt. This business about this tape as a murder weapon on the guess of probabilities. Could be. How many times did you hear somebody say could be, might be, maybe? And today's opening statement by Mr. Ashton, he said on several occasions, in all likelihood, a characterization that he made himself about something. In all likelihood. Well, in all likelihood doesn't quite make it. Let's talk about what burden of proof really requires and how it means and how you can think about it. You may have other definitions and other thoughts. Can you see them? You've seen it before. Sir, ma'am, all of you. If you have if you go and you listen to the rest of the arguments and the evidence and you talk about things, you just discuss it. Oh, sorry. Can you all see it? Okay. You may have an absolutely abiding belief now or tomorrow or whenever that is not guilty. And that's easy. Not guilty. Done. You may decide it's highly unlikely that she's guilty. Okay, good. All these mean not guilty. You may decide that it's less than likely, unlikely, possibly not, may not be, perhaps. All these you'd be thinking, well, I'm not sure, but maybe she's not guilty, possibly not, maybe not be, perhaps she's guilty. Also means perhaps she's not. Suspected. You might suspect that she's guilty. That's not proving guilt beyond a reasonable doubt. That's not here. Possibly guilty. Possibly guilty. In all likelihood. Possibly guilty. Probably guilty, moving up the scale. You have probably guilty of something. Guilty of what? Probably guilty of something, but probably guilty of what? Still not beyond reasonable doubt. Guilt likely, you may say. Why? You know, I'm confused, I'm befuddled, this is a bad deal, all these sort of things come together. You know, maybe guilt is likely. That's not beyond a reasonable doubt. Or I got a strong belief in guilt. No, no, and no. Unless the state has proven to you beyond and to the exclusion of reasonable doubt, then whatever these other, if these are your evaluation thought processes, or others that may be in your own mind similar to that, there's only one answer. It's not guilty. It's not guilty because the state hasn't proven guilt. Now, there are a few things in the world that are absolutely subject to clear proof in our life experiences. Very few. People can talk about 100% this, 100% that, like Dr. G said. The only thing I know that people are going to do, what 100% are going to do, is die. Anything else is 100%. We used to say taxes, but we know better than that now. A lot of people are not doing that. That's why we have the system that says the state has to prove beyond reasonable doubt everything. And if they fail to do that, then no matter what you may think in this continuum, strong belief, guilt likely, probably going on down the line, your obligation is to, wait a minute, they haven't proven beyond a reasonable doubt. If they don't prove beyond a reasonable doubt, not guilty. This is not a trick. One of the things I was just also thinking about, going back to that list of evidence, this bothered me because I don't know the answer. I don't know the answers to a lot of things in here. You don't either, I'm sure. Mr. Bias was talking about Mr. Kronk. Why, another question for you, why would an uninvolved citizen, after calling the police about finding the skull, in a situation that is really just hundreds of feet around the corner down the road from the Anthony residence where all cameras are, and so forth. Nationwide lookout. Y'all remember that? Said so during jury selection. Why in the world would the man sit silent for 4 months? I do not know the answer to that. I do not know how it is that he testified that he took his meter reader stick and put it in the right orbital socket of that skull and lifted it. Yet, the claim is that it was found embedded in the leaves and muck. Or was there, in fact, some repositioning, some posing, or something to make a case? Dr. Schultz said there was no tape on the nose. Dr. Garavolia said there was some tape in the vicinity of the mouth. She concluded that the manner of death was a homicide on totally circumstantial evidence, because she said so emotionally no child should have tape on their face. Well, there's no evidence that she did. Remember all the stuff, all the DNA, all the no. And Dr. Warren, who did the superimposition photo stuff, said it could have. So we have, in all likelihood, we have a could have, we have in the vicinity, may have. This is not a could have, may have, so forth. This is a charge of murder in the first degree and serious other charges of aggravated manslaughter and aggravated child abuse. We all know, you accepted, and I close with this. you have a duty. I have been doing this for many years. I'm an idealist. I believe firmly in the integrity of our courts and in the jury system. Ladies and gentlemen, the reality is a court is no better than each of you sitting before me on this jury. A court is only as sound as its jury, and a jury is only as sound as the men and women who make it up. I am confident that you will review without passion the evidence you have heard, come to a decision, and restore Caylee Marie Anthony to her freedom. And go do your duty. I will not claim origination for that. Some of you, you've watched so many movies, ask from Atticus Finch to Kill a Mockingbird. I do not get the chance to get up again and talk to you. So I ask you to do this. Pay the same respectful, intelligent attention to my colleagues, whichever gets up next. Realizing that we got to sit over there. I have to sit over there and squirm because I can't get up. Can't get up and say no, but. So I ask you to consider this. Any and every time an issue is raised that piques your curiosity and you haven't been satisfied that the evidence proves it beyond a reasonable doubt, ask yourself, well, what would Mr. Mason argue about that or say in response to that? And you do it. And then you do your duty. You light your candles for the Constitution, and you do your duty, and you find Caylee Marie Anthony not guilty because they have not proven her guilt. Thank you very much.
Okay, we'll take a 5-minute break before we proceed to the rebuttal argument by the state of Florida. Defense.
What do we do?
Okay, members of the jury, the time is now approximately 6:36. I've had the court deputy inquire, and I'm going to make an executive decision to recess for the evening. Some of you are doing fine, and some of you are tired. I want all of you bright-eyed and bushy-tailed. Been a long day yesterday. It's going to be a long day tomorrow. We're close to the end. Again, I'm going to ask that you not to discuss this case among yourselves, nor with anyone else. And we will see you where we will start at 8:30 tomorrow morning. Members of the jury, you're hereby excused. You may be seated. We need to complete the charge conference. I need to read over the final copy, which should take me about 15 minutes. And then we'll go ahead and complete the charge conference. There was a request made by the state of Florida. As I told you, I do not want to guess at the answer. I don't know the answer. It shouldn't take us long to do the charge conference. Whatever authority you have for that proposition, email it to me by 9:30 p.m. tonight. And I will look at.
I would draw the request. If defense counsel doesn't use them, that's fine.
Okay. Okay, we'll be at ease till I can go down and get the instructions. And then we'll complete the charge conference. Okay, we'll be at ease. Murder, first degree. Note the added language that the state has requested, which the defense has objected to. The defense can object to that portion and then indicate whether or not there are any additional objections.
Your Honor, we object to the deviation from the standard jury instructions within this instructions. Other than that, we have no objections, Your Honor.
That will be noted. State, any objections?
No, sir.
Going to page 5, felony murder, first degree.
The defense objects, Your Honor, based on our previous objections, and we would ask for a special interrogatory for a finding of multiple counts of aggravated child abuse as required for an underlying felony and a felony murder charge.
Okay. Note an objection, same previous ruling that I've given before. State.
No objection.
Going to page 6, aggravated child abuse.
No objections, Your Honor.
All right. Going to page 7, aggravated manslaughter of a child. One of the things you will note that in the statutory language, I kind of changed the title of the instruction to match the title of the count of the indictment. Let me know when you finish reviewing it. I know it's a long one. Remember, if you want to look over this tonight and have some things that we have overlooked, just let us know in the morning. But let me know when you made your quick review as of today.
Objection, Your
Defense?
Your Honor, we would object based on this simple neglect direction here. As we discussed previously, the problem is that the statute references that the death of someone under 18 references that other statute, the culpable negligence issue 827.03 sub 3, and includes not only this culpable negligence but also simple neglect. And we would object that that's a flaw in the standard, and that culpable negligence should be the standard, Your Honor.
Okay, same previous ruling as before. Any additional objections, Ms. Fryer?
No additional objections, Your
Okay.
Honor.
Moving to page 9. Still got your request for materiality?
Yes, Your Honor.
State?
Your Honor, the state objects to any alteration in the instruction that does not reflect the statute as written. We believe the statute as written, the requirement of intent to mislead is sufficient scienter to make the statute constitutional.
Noting the defense objection, their objection will be overruled. All right, going to page 10.
No objection to the state, Your Honor.
No objection, Your Honor.
All right. Going to page 11, second degree murder.
No objections from the defense, Your Honor.
Okay. You can remain seated, Ms. Fryer. You don't need to stand. All right, going to page 12 and 13, the instruction on manslaughter.
Objection from the state, Your Honor.
No objections, Your Honor.
Going to page 14, and one of the things I want you to closely look at with the third-degree felony murder is whether or not you want the second part of 2 dealing with the attempt of committing child abuse, because it necessitates a reading of the attempt, I believe, instruction. And if you look at your instructions, there are 2 alternative theories to prove the crime of attempt, or you give the second one. You may want to turn to your standard jury instruction book, and it tells you which one's applicable and not applicable. So let's first look at felony third-degree murder. If you want the second one, I may need to define attempt, or unless you feel we don't need to do that.
Defense requested it, so whatever they want to do with that is fine with us.
He's on third-degree felony murder, that's page 14.
Long day, folks. All right, Ms. Fryer, you requested the felony murder third degree.
Yes, Your Honor.
Do you want, the ones we talked about were 2A or 2B. There was no evidence of escaping or being an accomplice. Do you want 2A and B or just 2A?
You have it printed, we agree with, Your Honor.
Okay, so you want the alternative?
Yes, sir, we do. But we would also request a special interrogatory to find multiple instances of child abuse to not run afoul of the merger doctrine.
Again, I will not give that, deny that. Now, you notice that I defined down there what child abuse was. You have any objections to that definition? It's basically the definition that's contained in the standard jury instruction.
Just discussing whether or not we would add the definitions of willfully under that as well, as we have in other jury instruction. Yes. Your Honor, we would request that you also add under willfully the instruction that you have added.
You want me to define willfully?
Yes, Your Honor.
Anything else?
No, Your Honor.
Okay, add the definition of willfully. Now, do you want attempt to commit a crime since you have that second part of 2? And that would be 5.1. You may want to turn to your instruction book. If you have your little green book, turn to 5.2, which is, 5.1. You will see the preamble to prove the crime of attempt to commit child abuse. It says use when attempt is charged or is a lesser included offense. That will come about, that should be the one, but as opposed to that second, in order to prove the defendant attempt to commit a crime. One of them has to go, the first or the second one. Which one do you want?
The issue is simply in order to prove, and under attempt to, the defendant attempted to commit the crime of, and then the crime charged we're going to add there is child abuse. I would again assert that we need to find multiple counts of child abuse for this to
I
apply.
know, but the question
Okay.
I'm trying to get the answer is, you can't have both of those introductions to prove the crime of attempt to commit, or in order to prove the crime the defendant attempted to commit. I need to know which one of those you want to give. You're requesting it, and I'm gonna give which one you want. I'm gonna let you pick, not me. Can't have both. So if there's an error, you'll make it and not me.
We'll go with the second one, Your Honor, that looks more detailed.
All right, you wanna, and the second one reads, in order to prove that the defendant attempted to commit the crime of child abuse, the state must prove the following beyond a reasonable doubt. That's the one you want,
Yes, Your Honor.
okay? All right, any problem with 15? Defense?
No, Your Honor.
All right, going to page 16, child abuse.
From the defense, Your Honor.
State?
No objection, Your Honor.
Going to page 17, reasonable doubt, plea of not guilty, burden of proof.
From the state.
Objections, Your Honor.
Thank you. Going to page 18, weighing the evidence. We give 1 through 8.
No objections, Your Honor.
All right, page 19. The defense requested instruction that the court modified.
No objections from the defense, Your Honor.
State?
Objection.
Page 20, expert witnesses.
No objections, Your Honor.
None from the state.
Page 21, defendant not testified.
No objections from the defense, Your Honor.
None from the state.
Page 22, defendant's statement, where the defense had requested addition, which the court declined to give. You renew that request again at this time?
We do, Your Honor.
Same previous ruling. Any additional objections to the instruction as it is presently worded?
No, none from the defense, Your Honor.
23, rules for deliberations.
No objection from the state.
No objections from the defense, Your Honor.
Page 24, cautionary instructions.
No objection, Your Honor.
No objections.
Page 25, verdict.
No objections from the defense, Your Honor.
Page 26, single defendant, multiple counts.
From the state.
Tracks the statute. No objections from the defense, Your Honor.
Page 27, submitting a case to the jury.
No objection, Your Honor.
No objections from the defense, Your Honor.
All right, let's go back and take up the defense's specially requested instructions on theory of defense. The first one we will take is the long one, which is called jury instructions, theory of defense, which is 1, 2, 3, 4, 5, 6, 7 paragraphs. State any objections.
Yes, sir. As previously argued, this is a factual statement. It doesn't contain any legal propositions that are not already contained in the standard instructions, and it would be an improper comment on the evidence by the court to give this instruction.
Okay. It still suffers from the same problems that I said earlier today based upon the Stevens case that I cited. Going to the second one. Theory of the defense jury instructions, which consist of 3 paragraphs.
Well, it's a shorter, but still basically just a statement of factual opinion or argument that defense counsel has already very eloquently made, and the court, I don't believe, needs to make it repeated for him.
Ms. Fry, anything in addition other than what you previously argued?
Your Honor, this second and much shorter theory of the defense jury instruction only is being asserted under the guidelines given by the court, in that there are legal principles involved here without any editorial or commentary as to the evidence. So it's our position that just as the indictment is the theory of the prosecution, the defendant is entitled to her theory of defense as well under authority of the state and federal government.
All right, based upon Stevens versus State, the court will deny the instruction in that the standard jury instructions adequately cover everything that is requested. And 2, that this again cites factual as opposed to legal theories, and to point out Mr. Baez and Mr. Mason both have quite eloquently pointed out what those theories were and how they applied to the law. Mr. Mason waxed quite well on the burden of proof and reasonable doubt, and what a reasonable doubt was. Gave some poignant and exquisite quotes that never seem to die. and brought him to life. All right, anything else? Now, have y'all looked at the verdict forms? I will file these two requested instructions with the clerk so that the record will be abundantly clear that they were, that the requests were done in compliance with the rules, that they were submitted in writing. All right, each of you got copies of the verdict forms?
Yes, sir, I provided a copy to the defense a few hours ago.
Verdict as to count one.
Could you give it to me? I'm sorry. Just a moment, Your Honor.
Defense ready?
Yes, Your Honor.
All right, verdict as to count one, first degree murder. Any objection to that verdict form?
On page, on first.
Not as to the first one, Your Honor.
All right. Verdict as to count two, aggravated child abuse. This is where you want to come in with your, what's your case?
Brooks?
Pardon?
Is it the Brooks case, Your Honor?
Case we've been talking about since day one. Can't think of the name now. It's getting late in the evening. The case dealing with the multiple acts.
That's the Brooks case, Your Honor.
Yeah, Brooks.
What about attempted?
I think you wanted in, your objection was that the verdict form should include an interrogatory verdict form specifying the number of acts per Brooks. Correct?
Yes, Your Honor. Yes, Your Honor, that's correct.
Court, same previous ruling. Other than that, do you have any additional objection to the verdict form other than the defense's contention that the verdict form violates Brooks?
Other than Brooks, Your Honor, we would also ask for an attempted charge as the underlying, as a lesser. Is that right?
Attempt or what?
Mayor, is that? Wait a second. I'm sorry. Hold on just a moment, Your Honor.
Yeah.
Other than the Brooks issue, we have no objections, Your Honor.
Okay. All right. Moving to verdict form as to count 3, aggravated manslaughter of a child. And you need to read that in conjunction with the special finding as to count 3. Read over those two and sing out when you're finished, defense.
The lesser of neglect of a child was left in there, but I thought you had said you weren't going to give that. 'Cause
Left
in-
where?
In a verdict count 3, there's a lesser of neglect of a child. I thought you'd indicated you were not going to give
Where
that.
do you see that at?
Is that not in your copy, Judge?
Which copy? You gotta tell me what you're talking about.
Verdict as to count 3, the main verdict.
The main verdict form?
You talking about the verdict form?
Yes.
Yeah.
I'm looking at verdict as to count 3. We, the jury, find the defendant guilty of aggravated manslaughter of a child. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant not guilty.
He's looking at an older version, apparently.
Oh,
I'm sorry about that.
I know it's late.
It is.
Yeah. My only concern, let me double check something, is in order to have an aggravated homicide, you gotta have two things. There's no finding that she was a child.
There should be two special verdict forms,
Maybe I didn't get to the second one.
special finding two. is
Just
the-
a second.
Sure.
Yep, you're right. I'm sorry. Then that alleviates my concern. Defense sing out when you get the verdict as to counts 3 and the 2 special findings. Those will take care of any apprente issues.
Your Honor, we don't have the special findings, and
You want to come take a
I
look
would,
at-
if you don't mind. May I approach?
Yes, ma'am.
We have no objections as to the jury instruction and the specials, Your Honor.
Okay. Let me have those back, because I'll be looking for, well, the clerk will be looking, she'll be looking at me strange when I ask her for them, so, because I'm going to give these verdict forms back to her. All right, verdict as to count 4, 5, and 6, and 7. And Madam Clerk, pull out the copy of the indictment that will go back so they can just come up afterwards, so they can inspect it. I want both sides to look at it. Huh? Yeah.
Your Honor, 4, 5, 6, or 7.
Okay, would the defense has the state looked at the indictment?
We have a copy, yes.
Nah, you need to look at the one that's going back. Want both sides to look at it. On the first page, if you look at the original indictment versus the one, I specifically had them delete that it was sealed and filed in open court, issued capious, bond set at none on all counts. That does not appear on the indictment that will go back. It does not include page 5, which goes to the case numbers, the counts, name, capious, and all that other identifying information. Any objection from the state of Florida?
No.
And after the defense has had a chance to peruse it, Any objections from the defense? Okay. Okay, return that to the clerk. I will make what small corrections we need to have, and you'll have copies in the morning. Anything else on behalf of the state of Florida?
No, Your Honor.
Defense?
No, Your Honor.
When the case goes out tomorrow, while you're waiting on the verdict, I will call your attention to the following two cases that was decided by the Florida Supreme Court on June 30th. Thursday. Ballot versus State doesn't have a citation number, and Scott versus State. Curious thing about, huh?
What's you spell it?
Ballard versus State, B-A-L-L-A-R-D.
I got balance.
Duct tape case, nobody. Interesting thing about that, it dealt with proportionality. The same thing with Scott versus State, another proportionality case. You may find them interesting reading. Published Thursday at 11 o'clock. Anything else for the good of the order?